It's very difficult to fathom how a state can be permitted to interfere or have the power to obliterate someone's religious identity.
Where does this thinking come from that somebody, just overnight becomes a Muslim and then creates a waqf? Like, where is this coming from?
Today, what the court seems to have done is try and keep some kind of a balance. But to my mind, it's going to turn into a bit of a mess, unholy mess, in short.
Hello and welcome to In Focus. I'm G. Sampath. Earlier this week, the Supreme Court of India stayed certain provisions of the Waqf Amendment Act 2025, but it refused to freeze the law in its entirety. Among the provisions stayed are the one requiring a person intending to create a waqf to prove that he had been practicing Islam for 5 years. It also paused the provision granting district collectors the power to determine the status of a disputed waqf property, and it also capped the non-Muslim representation in waqf boards. But at the same time, it has upheld the deletion of waqf by users, another contentious issue flagged by the petitioners. But this is only an interim order and the case will be heard on merits sometime in the future. But for now, the government is free to implement the new law except for the state provisions. So, what are the implications of this interim order and how will it change things on the ground? To help us understand the legal import of this order, we are joined today by eminent advocate Tasneem Ahmadi. Tasneem, thank you so much for coming to our office. Welcome to InFocus.
Pleasure.
So, to start with, I was just wondering if you can just explain the concept of waqf. What exactly is it?
Okay. So, Waqf is basically a dedication to the Almighty. There are two words that you need to remember. One is Waqf and the other is Waqif.
Other one is?
Waqif.
Okay.
The Waqif is the creator of the Waqf.
Okay.
So, the tenet of Islam is that you will, if you can and you are able to, do charity for the other humans who are not able to meet two ends or whatever their purpose. So, therefore, it's a dedication to the Almighty. Now, you will not do it in your name, you will do it in the name of the Almighty. So, the minute you create a waqf, the property then vests with the Almighty. You don't get credit for anything that you do, it's in the name of the Almighty. So, there have been waqfs over years, centuries, where you have hospitals, you have orphanages, you have homes for destitutes, you have mosques, and you have many others. Basic idea is I give back to society. And understand one thing, what happens to the property? The Waqif is actually depriving his children from inheriting that property, and he's giving it away for the betterment of humans. So it's a dedication to the Almighty done with the intent of helping humans over time immemorial, because then it just goes on. Once a waqf, always a waqf is the principle. Once it's dedicated to the Almighty, it remains there. So basically, in a nutshell, that's what a waqf is.
Right. Thank you for that, Tasneem. So now, when it comes to this whole dedication process, we have something called waqf by user, right? So now the Supreme Court's interim order on this 2025 Act, it has upheld the deletion of the waqf by user, which this Act does. So is that a problematic thing? Because they are saying that everything has to be registered in writing, etc., etc. So what are your thoughts on that?
Okay, so to give an example, what is a waqf by user? A waqf by user is a situation where I allow a part of my property, for example, to be used as an orphanage. And because it is used as an orphanage, it just continues. I have not done a formal waqf deed. Now, Islam recognizes an oral gift. So, therefore, one does not need to have a written gift deed, which a waqf deed is, in a manner of speaking, a written gift. So, this continues over time. The interim order, which does not protect the waqf by users, will create problems. What happens now? The waqf is not a waqf anymore. Therefore, it will revert back to the owner. Now, the owner may not be there, there might be legal representatives. So, effectively, the legal representatives will take control. The Waqf board, which was getting an income out of it, will stop getting an income. The Mutawali will not be there anymore, but the owner will be there. So, effectively, what has one achieved? One has achieved only a user stopping and ownership going vesting back with the.
But the users can take it to court, and in which case, the Waqf tribunal will be the one deciding, right?
So no. So when it reverts back to the original owner, you will have an issue where the original owner will want to continue it as the orphanage or not. Otherwise, the burden of that orphanage will now fall on the state. The state will have to take responsibility. Similarly, I mean, it's has a retrospective effect, in my opinion, because what it is doing is it is undoing the works that were already there. If one were to say that in future there will be no works by user, it was like we've been a slightly different.
But isn't that the sense of the order? Because it
The
says now
order
you have
says now
time
you have
to your
time
time
to
to register.
register.
Yeah.
But now the registration under 36 says you need a work deed. A work by user by itself, an implication, an understanding is that there is no work deed. It's by user. So therefore, if it is by user and there is no work deed, what happens? It goes back to the owner. And it is retrospective because it was already there and now it is being undone. Now, it will be confusion confounded because there will be people who will claim ownership to that particular property. There may be more than one, there might be three, there might be four. Then there will be litigation as to who is the owner, whether the orphanage, for example, it continues or not is a question mark. So then state will have to take responsibility and will have to build another orphanage somewhere else for all those orphans. It's a situation which will create unbelievable confusion. One. Two, it is also a situation where you will have the uh, litigation that will increase manifold. People will, all of them will claim because we don't know who are the owners. And then what happens if ultimately in the final decision, this entire amendment is set aside because there might be third party rights in that property? So will you be able to then revert back to what it was before the amendment? These are all questions that that have no solution, only causing confusion.
But the court order has said that there is some justification merit in the whole problem of encroachment of government lands in the context of waqf by user. So how do you address that aspect?
If it is government land, then the encroachment can be removed by the concerned authorities. The law is there. If anybody is encroached onto public space, say for example DDA has its own provisions. You can remove somebody. Similarly, all the development authorities of different states, UTs, have cities have their own provision for removing.
But waqf by user does not have a deed,
It's
right?
not something. It's not something that you can't do, and you need an amendment in the Waqf Act to remove encroachment on public land. It's catching.
So that's not a relevant argument in this
To
case.
my mind, no.
Okay. So the court has offered a protection to waqf properties that are monuments, but at the same time, the petitioners have contended that a waqf property would lose its status if it was notified as a protected monument. So is this a justified apprehension?
All right. So we have to go back to the Ancient Monuments Act, 1904 and 1958. These are the two that have been. Now, both these acts need to be read carefully. These acts provide that the ASI, if it's a protected monument, the ASI first has to enter into an agreement with the owner. So the owner is the one who will then be the person who will decide and permit the ASI to do certain things to protect the ancient monument. Now, again, once you say that this, if it's an ancient monument, it does not continue as a waqf. Now we have to look for the owner. Once the owner is found, then the ASI will be able to enter into an agreement with that owner. Only then will the ASI be able to do anything with the property. So effectively, you are achieving no goal. What is happening earlier? What was the situation? It's a protected monument or not a protect? If it's a waqf, it's taken care of by the mutawali or the waqf board. The waqf board and is paid a certain amount from the proceeds of that particular monument, and it enjoys those proceeds. Now there will be no mutawali. There will be nothing. However, as per the judgment of the Supreme Court, status remains the same. You can't change it. So therefore, if it's religious activities, the religious activities will continue. So effectively, religious activities continue without a mutawali, but with an owner. And the ASI will first have to find an owner. Till then, the ASI can do nothing, because we are then governed by the Protection of Monuments Act.
So on the
Ancient
ground,
Monuments Act.
so what is the problem with this on the ground? You just won't have those proceeds coming in. That's the only difference.
There'll be litigation. See, the courts are going to be inundated, because now, if you're looking at an ancient monument, one is looking going back in the 1800s or the 1900s. Therefore, all these places, now there'll be, I don't know how many claimants who will jump up to say that this is my property.
No, but they all will have to produce some proof,
Correct.
some
So
documents.
look at the time now. If I claim to be the owner or the legal heir of the erstwhile owner of an ancient monument, which was a waqf property, I will now say that it now reverts back to me because I was the legal heir. And now that I am the legal heir, please give it to me. There'll be 3 other siblings or others, strangers, who will say, no, 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 she's not, I am. Therefore, now get a declaration from a court as to who is the legal heir. Till then, ASI can do nothing, because ASI will have to enter into an agreement with the owner. ASI can't just enter and say that I'm managing the property. They can't, because their role is subservient to the owner's role.
But the owner goes out of the picture once a property becomes waqf by user, right? The owner may not be in the picture.
That's the whole thing. But what is happening now? By saying that it's no more a waqf by user, that means that waqf is not a waqf anymore. Where does the property go? It reverts back.
Doesn't it revert back to the state?
How can it go to the state? How can it go to the state? A waqif has created a waqf. Today, the court says waqf wrongly created. If waqf wrongly created, it goes back to the waqif. State has no role to play. State cannot take ownership.
Okay. The Supreme Court has also held in another contentious provision that there is nothing wrong in requiring a person to prove that he had been practicing the faith for at least 5 years, if you want to be a waqif. Now, it has justified this by saying that waqf endowments are being misused, I quote here, as a clever device to tie up a property in order to defeat creditors and generally to evade the law under the cloak of a plausible dedication to the Almighty. So it says that it is being misused. Those who are not Muslims, they might create a waqf to evade their creditors. So, what are your thoughts? I mean, is it constitutional to prohibit non-Muslims from creating waqf?
So the Constitution gives every citizen the right to freedom to practice his or her religion. That's his constitutional right. The Constitution also gives a right to hold property, and is supposed to be now considered as a human right. Now, when I look at a 5-year provision, the Constitution doesn't say that I have to practice a particular faith for 5 years to be considered as belonging to a particular faith. Where does this 5-year period come from? It's completely arbitrary. Why 5 years? Why not 5 months? Why not 5 days? Because I can today convert to Islam and after a year convert to Christianity. It's my freedom. The Constitution gives me that freedom. And I can after that convert to something else.
There is a presumption here that if somebody converts just one day before and then the next day is endowing, creating this endowment, then that's purely as a way of,
To have that kind of a presumption, there must be some cogent evidence. There is no cogent evidence on the record to show that something like that is happening. So we are now in the realm of fiction. So something like this might happen. Our imagination has taken us there. And then we turn around and say that, oh, because of this, we put a 5-year cap. Why 5-year cap? And if I am wanting to give up my property for something like this, in to avoid paying my creditors, that is something that one can always challenge in court to say that, look, converted today, a property became a waqf and now reconverted back. So there are courts that can look into this. It's not as if it can't. And what does that person gain? He runs away from his creditor. He doesn't really, because the creditor will still follow him. But he loses his property also. So what's the logic? There is no logic in this entire thing that that in order to cheat your creditor, you will now convert your property into waqf. The creditor is not going to go away, and you have lost your property as well.
right. It is a bit of a difficult logic to understand. But Tasnim, on the other hand, what about this entire line of argument that now the state governments are going to frame rules to decide, who's a Muslim who's eligible to create a waqf. I mean, is that something we're going to see now? Like, how does that?
It's very difficult to fathom how a state can be permitted to interfere or have the power to obliterate someone's religious identity, because that is what it will be doing. Rules are framed for what? To decide whether I belong to A faith or B faith. How can the state be allowed to do that? Under which provision of law? The Constitution doesn't permit me, it gives me the freedom. I can profess any faith that I want, and for a whatever period I want. So therefore, obliterates somebody's religion or religious identity, to my mind, an exercise in absurdity. I'm sorry.
But where is this coming from? Are there any cases where somebody gets married and then therefore they convert and then they end up creating a waqf? This thinking at all, and I'm trying to understand, like, where does this thinking come from that somebody just overnight becomes a Muslim and then creates a waqf? Like, where is this coming from? Have such things happened in certain other like existing legal disputes which have arisen from these kinds of
I have not
practices?
come across a single one. I really haven't come across a single one. I have seen Hindi movies which say so, but so we have to first wait and see what rules are being framed, if at all they are framed.
And the rules will be different from state to state?
It looks like it. And who's going to frame that? What kind of knowledge do they have about a particular religion? How are they framing rules?
There is an expectation that the minority affairs ministry department, whatever, might frame.
Let's see. But then who in that minority affairs department? See, the whole concept of a state being secular will stand completely obliterated if it is supposed to allow the state to determine somebody's religious faith. It's a secular state. We can't do this. To my mind, we can't.
Okay, so there is one other provision which has been stayed, which has been welcomed, by various Muslim organizations, which is at Section 3C, where earlier as per the law, the district collector could actually enter a dispute and then take a call on what is the nature of this property. Is it a work property? And then until that is completely settled, the property, the nature of the work property can be changed, until the whole thing is resolved. But now the Supreme Court has said until the entire matter is resolved, there will be no change in the nature of the property, and the district collector is not somebody who can decide this, because you need separation of powers between the executive and the, so this has been sort of, I think, widely welcomed. So what are your thoughts on this? It's a positive
See,
development.
3C was a blatant attempt by the government to expropriate work properties. It was based on the mere whim of a government officer who could just casually decide that this is not work property, but this is government property. And for that, we need to understand the insertion of two definitions in the Waqf Act, which was 3FB and 3FA. 3FB defined what government property would be, which said any property belonging to a government organization. I'm giving you in a nutshell. I don't have the entire definition with me. But that is what 3FA said: government organization. So the property belonging to a government organization, and then government. What is a government organization? A government organization includes central, state, panchayat, subordinate offices, autonomous bodies of the government, any organization and institution owned and controlled by the government. So all these become government organizations, and any property of that particular organization would be government property, and anybody could then say that this is the property of this organization. So you have even from the panchayat, somebody could jump up and say, "Yes, this is not waqf, this is government property." And then what happens? It immediately loses its character of waqf, and a designated officer is appointed. The designated officer will go, have an inquiry, give a report, and if the report is that it is not waqf, but it is government property, then the revenue records will be changed accordingly. So all rules of natural justice gone, everything over, and the executor will be deciding what is his own property. So basically, what the court has done is you can't be a judge in your own cause. The judiciary will decide. And therefore, where title is concerned, you also already have the waqf tribunals. The waqf tribunals will decide this question as to whether it is a waqf or not a waqf, and up to the High Court. So effectively, over here, the court has clamped down, saying while this matter will be heard finally, you can't expropriate waqf properties like this. And nor can you be allowed to take the call of which is a waqf property. That's a judicial body that will do it. And that's the separation of powers, because the executive can't decide. It is the judiciary that will decide.
Right. So, I mean, from what you're saying, it seems like a pretty obvious attempt to sort of usurp waqf property without due process of law.
Yes.
And I think it's a very basic kind of a clamp down on this.
Yes, it is. It is. It is.
Okay.
It is.
Okay. The other contentious provision on which the court's decision has been welcomed is capping non-Muslim members of Waqf Council at the central level at 4 out of 22, and at the state Waqf boards at 3 out of 11. I mean, there are two views. One is that, okay, it's good that the Muslim majority is being protected. But on the other hand, there is also this view that, why are we making non-Muslim representations mandatory when other religious bodies which are equivalent don't have provisions for Muslims or other communities to be represented? So there are these two views. So how do you understand and reconcile these?
So I'll give you a third view. On the one hand, there is that provision that non-Muslims cannot create waqfs. Has not been stayed, and therefore non-Muslims cannot create waqfs. And the reasoning behind it is that because it is an Islamic tenet and something to do with the Islamic religion only, specifically the Islamic religion. Then, on the same basis, why would you have non-Muslims on something that takes care of Islamic religious activity, i.e., the waqf? It's a paradox which one needs to think about, because why earlier all the members of the board as well as the council were Muslims, and there was an election. Now it's all nomination.
Now there will be no elections.
Now there'll be no election. There'll
What
be
about the
nominated.
chairperson? Is there any kind of indication on the chairperson can be non-Muslim? Is that allowed now?
It's the indication is that they will try and they hope that the CEO will be a Muslim, but no, if he's not, he's not. It's
So
only
a non-Muslim can be the head of a waqf board.
Yes. And the Solicitor General made a statement, which was recorded in this judge order, that the functions meant to be carried out by such non-Muslim members are only with regard to laying down general policy and non-religious oblique secular activities. But what are those?
They have not been defined,
No.
listed.
No. And how does one know that general policy will not apply to religious practices, especially when the entire principle of waqf is religious? It's a dichotomy which one needs to figure out, which is going to give rise to lots of problems in the future.
Right, but yeah, I mean, I hadn't thought of it this way. That's an extraordinary contradiction which you pointed out, that Muslims cannot create waqf because it's an Islam tenet-based thing. But then you also have non-Muslim representation in an Islam tenet-based thing. So how do you reconcile these two logic? You can have this logic or that logic.
You can't have both. Yes. Which are polar opposites.
Polar opposites, right? Okay. So what are your thoughts on the question of this exempting recovery of encroached waqf properties from the Limitation Act 1963? I think until the 1995 Act it was there, and then it was changed subsequently.
Yes. So, see, the principle that was enunciated by the Supreme Court time and again was waqf, once a waqf, always a waqf. And that, in my opinion, is the Supreme Court that has held that. So, therefore, in the principle of committee of judgments, in the final order, presumably the court will look at it. This is an interim order. Now, it's odd that limitation will apply to any claim or interest pertaining to a immovable property comprised of a waqf. So, if a waqf has been encroached upon and the mutawali files a suit, then limitation will apply. So, if it has been encroached upon earlier, they will say, now, no, sorry, you can't come. Limitation will apply. But if you see the proviso to Section 6, so if a property is a waqf property or not, if there's a dispute that if a property is a waqf property or not, then limitation can be waived by the tribunal. So if somebody wants to dispute that this is not a waqf, then he can go to the tribunal, and the proviso says that if he shows just cause or sufficient cause, this limitation can be waived. But on the other hand, if you're trying to reclaim work property, then there is limitation. So again, there is a paradox.
So the limitation is like a one-way door kind of a thing. So if you want to reclaim a waqf property which you think is encroached upon, the limitation will apply. If you want to say that, okay, this is not waqf property, and you want to reduce an existing waqf property, the limitation does not apply.
So you go to the waqf tribunal and you say that this was the reason why I could not come on time. Please waive. The tribunal has the authority to waive it.
But the tribunal is a Muslim majority kind of a body, right? So it may rule
I'm not looking at it from that point of view. I'm really not looking at it. I'm just looking at it from the point of view of the law as it stands today. Whether it's a Muslim majority or not a Muslim majority, and a tribunal is a judicial body. I wouldn't want to comment on that.
Right. My last question, Tasneem. So this law with setting aside the state provision for the time being. Now it's going to be implemented from what maybe it's already started getting implemented, and now it will be heard on merits at some point of time. So in this interim period, from the interim order till the time it is heard on merits and finally settled, like how do you expect things to unfold on the ground? I mean, like are there certain kinds of court proceedings which will be sort of held back uh, so that the final judgment is heard, or is that going to be like so far into the future that things are going to settle down into a new normal?
So, where the interim order is concerned, it has not held back anything, saying that court proceedings will be held back. So, and in fact, has gone on to say that the Waqf Tribunal will decide issues of title in terms of work property. So, therefore, there is no holding back. So, effectively, what I see is a lot of litigation. If it's evacuee properties, you will have the same problem, because how do you decide that this was evacuee property?
What exactly is an evacuee property?
Okay, so an evacuee property is a property that was left behind by somebody who left our country during partition and went off to Pakistan, leaving his properties behind. So those became evacuee properties. Now, in a waqf, if it is a waqf, it can't be evacuee property because it rests with the Almighty. Now, today, that particular provision also has not been stated, that evacuee properties will now cease to be waqf properties. How is one going to decide which waqf was an evacuee property or not? Because if the waqf was formed before in partition, then it was a property that belonged to the Almighty. It didn't belong to a human being who left India and went to Pakistan. So, how do you determine which is an evacuee? Similarly, if at all you do determine that this is an evacuee property, you will have to go through the entire process of notice, objections, so on and so forth. Then determine that it is evacuee property. After you determine that it is evacuee property, then there will be claims that, and our history shows us that evacuee properties, I mean, there are n number of cases where wrongly declared as evacuee property because that person disappeared for some time and then appeared again and said, I have never left, but because of the riots, I was in hiding. But this is my property. So, and the custodian has then reversed all those findings and holdings that these are evacuee properties. So now you will have another series of litigation going on with the custodian, that this is not evacuee property, but this is my property. Revert it back to me. So, and if it is a place of worship, it will remain a place of worship because the Places of Worship Act will apply. So the Places of Worship Act has already come into force. So it will remain what it was. The custodian will now have a slew of cases. Then ultimately, who is the owner is something that courts will decide, civil courts will decide, because everybody will claim ownership.
So now this Waqf Act, I mean, after the Supreme Court's interim order not doing anything about this provision, it means that there will be a slew of cases claiming that an evacuee property, some Waqf property is an evacuee property, and therefore it is not a Waqf property.
So the first step is for the government to decide which is an evacuee property, because that is what they'll have to decide. In order to decide, they'll have to issue notices. After issuing notices, then they'll have to decide the claims. Thereafter, there will be an appeal to the custodian. So this government is not going to be able to handle these properties, if that is what your question is, because the property doesn't vest in the government at all till this is not decided as to who the owner is. Because by cancelling a waqf, all that you're doing is you're saying, I am cancelling what the creator of the waqf did, i.e., give his property to the Almighty. So it reverts back to the creator of the waqf or his progeny.
My final question, Tasneem, now there is underlying all this discussion underlying everything the Supreme Court's interim order has said is this basic foundation of presumption of constitutionality of any legislature. It is legislation which is passed in Parliament, and on that basis, the court has said that okay, certain key provisions we can look at and we will, but otherwise we have to presume. So, can you explain what does this mean? Like, how can there be an automatic presumption of constitutionality regardless of the content and substance of whatever is the legislation? How does it work?
That is the court's interim order. It's not the final order. So, as and when the final order comes, I think this question might be more relevant at that time, if at all the act is not struck down. Today, what the court seems to have done is try and keep some kind of a balance. But to my mind, it's going to turn into a bit of a mess, because every provision that is allowed to stand today is only going to give rise to complications and litigations, and nobody is going to benefit. The people who were benefiting from this charity will now become a burden on the state, because waqf was a method where a lot of orphanages, homes for destitutes, charities in terms of providing food took place on a regular basis. Now, all that will have to be taken care of by the state. The state is going to lose even that income that the Waqf board got from the income of the Waqf properties. So that is also something that is lost. The courts will be burdened with cases. The custodian will be burdened with cases. They'll have to build infrastructure for that. And ultimately, what have we achieved? It's just a unholy mess, in short.
Unholy mess. That's a pretty grim note to end this
Yes,
conversation
I'm
on.
sorry, because of the litigations that we are seeing, which one can foresee as a lawyer. So what is going to happen? And the unfortunate part is, who will suffer? Is the poor who will suffer. The people who lived on this charity who will suffer. And whether the state will provide them with what they have lost is a question mark. So, from that point of view, yes, it is sad.
Right. I mean, on the positive side, a forcibly positive spin, if you can put on it, this is still an interim stage.
It's an interim stage, and
and
therefore we have to wait and watch. Let's hope that it's heard early and decided one way or the other.
right, we can hope
Because
for that.
to put back the clock will be very difficult.
That's all I have for you, Tasneem. Thank you so much for joining us. Thank you. Pleasure talking to you.